Welcome to the deep dive. Today's mission is, well, pretty ambitious. We're covering a huge sweep of time, over 1,000 years, really, and looking across the whole ancient Mediterranean.
That's right. We're diving into the sometimes chaotic, often really brutal development of law and political power.
Yeah, tracing how different societies think Athens, the democracy, all the way to the vast Roman Empire, how they actually tried to nail down what justice meant, and crucially, how to control power.
And we've got some fantastic sources today. They really show, I think, that law wasn't ever just a static set of rules you look up in a book.
No, definitely not.
It was alive, constantly changing. It could be a weapon in political fights or a shield for certain groups, and it always reflected the social hierarchy of the time.
We'll see how practical needs, just, how society functions day to day and these intense political struggles really fundamentally reshaped legal ideas over this huge time frame. So we're starting not with fully formed legal codes etched in stone, but way back in the kind of murky origins of governance in Greece. How did they even get from pure revenge to something like state justice?
That's the core question, isn't it? Our mission today is really to track that evolution. We'll contrast the Athenian approach, which was so much about public performance, the agon, persuasion, political fights playing out in court.
Right, the rhetoric.
With the Roman way, which became much more about systematic rules, professional lawyers, the jurists, and eventually a very formalized system where your legal status determined everything.
It's a journey from maybe the personal public argument to the often quite cold, impersonal machinery of the state.
Okay, let's dig into that shift. Starting right back at the beginning, before writing was common, before laws were posted publicly, what did law even look like? And who held the keys to that knowledge?
Well, you're talking about the era of customary law, what the Greeks themselves called true unwritten law. And the big problem, obviously, is how do you preserve it?
If it's not written down. Exactly. It gets forgotten, twisted, manipulated super easily. So the only practical solution they really had was to keep it confined. The knowledge of the rules, the important distinctions, the customs, it was held exclusively by a small, privileged group.
An elite.
An elite, yeah. An aristocracy, maybe a specific caste, sometimes a priestly college. They essentially had a monopoly on knowing the law. And that monopoly was, right from the start, a cornerstone of their political power.
So power came directly from controlling that institutional memory, basically. And we see this control taking shape in Athens during that crucial period of constitutional change, specifically when the archons come to prominence.
Absolutely. The whole decline of kingship in Athens, it was complicated. The title king or basileus, it actually stuck around in some form for ages, often just ceremonial by the end.
Symbolic role.
Right. But the real power, that was definitely seized by the archons. These were the leaders of the rising aristocracy, families like the Medontides, for instance. They were the ones setting the new political agenda.
And these aristocratic archons, they're the ones often credited with the Cynicism. We hear that term a lot. What did that Union of Attica actually mean on the ground? More than just drawing lines on a map, presumably.
Oh, much more. The Cynicism, this political and social merging of Attica, maybe around the 9th century BC, we think it was a massive undertaking. It wasn't just about geography. It was about creating a central state, a structure where law could actually be applied uniformly across the territory.
Which requires organization.
Exactly. And that led directly to things like dividing people into the 4 tribes, which, interestingly, the Athenians seem to have borrowed from Ionian practices elsewhere. The very act of building this unified state both required and reinforced the power of this aristocratic class who were designing the whole legal and political setup.
Okay, so fast forward a few centuries from that foundation. The day-to-day practice of law in the later Athenian polis, it seems shaped by something much more dynamic, almost like you said, gladiatorial rhetoric and this political idea of advantage.
Yeah, what really jumps out from the sources is that lawsuits in Athens weren't some separate, sterile legal process. They were tangled up completely with social and political fights.
A part of the fabric?
Totally. It was part of how you defined who you were in society. You see politicians openly arguing that laws should aim for both justice and the advantage. Going to court, making claims, defending yourself. It was all tied into these key social activities. Showing you were strong, getting public opinion on your side, and really importantly, managing revenge in what was fundamentally an agonistic society.
Meaning competitive, contest-driven.
Contest-driven, exactly. Winning in court wasn't just about being right in some abstract sense. It was about proving your strength, your honor, your place in the pecking order.
Sounds incredibly intense. And if the whole legal system is so tied up in social conflict and winning arguments, What happens if that delicate political and legal balance just collapses?
We get a horrifying glimpse, actually, from the Civil War in Corcyra. Thucydides gives us this incredibly raw account of what happens when the system breaks down utterly.
What happened there?
Well, when the Democratic faction finally got the upper hand over the oligarchs, he says the most vindictive and inhuman passions just exploded. The killing that followed wasn't just political targeting. It was a total meltdown of social norms.
Oh, wow.
Yeah, we hear about fathers killing their own sons, people desperately seeking sanctuary in temples, supposedly sacred ground being dragged out and murdered right there. All the basic rules, the protections, they just vanished.
Chilling.
It really underscores the massive importance of maintaining that formal system of justice in the polis, because when it fails, the chaos is immediate and devastating.
Which makes that philosophical shift away from the endless cycle of tit-for-tat violence, away from pure vengeance, just so incredibly critical. And the text that really captures this for the Athenians is Aeschylus's Oresteia trilogy.
Absolutely central. It was produced in 458 BC, and it's basically the founding myth for Athenian state justice. The climax, Orestes' trial for killing his mother in the final play, the Eumenides. It's not just a drama. It's the city symbolically embracing a new way.
Right. It depicts the very first murder trial presided over by the court of the Areopagus.
Precisely. And you have the old forces of vengeance, the Furies, literally prosecuting him.
Yeah.
They want the cycle of killing to continue the plague calls, crimes, the child of former bloodshed.
But the state intervenes. The goddess Athene herself steps in. How does she manage to break that cycle and set up this new court system?
Athene doesn't just deliver a verdict based on the old rules. She establishes a process, a formal trial. And crucially, she finds a way to appease the Furies, to persuade them out of their rage against Athens by giving them a new respected role within the city's justice system.
So integrating the old forces into the new order.
Exactly. It's the polis saying, we are now in charge of defining and delivering justice, not just individual families seeking revenge. But even in this moment of triumph for the new system, there's still this shadow, this recognition. Yeah, a sense that, as the tragedy puts it, people are still kind of mired in an existence determined by a past over which he has no control. Even the Furies' final blessings acknowledge this sort of inherited burden, the idea that suffering happens because of mistakes made generations ago that still demand some kind of reckoning. The past isn't just wiped clean.
And that tension between the ideal of orderly justice and the messy reality of human conflict and history, it carries right over into Athenian public life. The courtroom didn't stay a pure forum for truth. It became a major arena for political combat.
Oh, completely. It was the ultimate stage for political careers. For any prominent Athenian, a big trial could make or break them. Fame, exile, sometimes even death hung in the balance. The courtroom really was just an extension of the assembly floor.
And the classic example is that bitter, long-running feud between Demosthenes and Aeschines.
That's the one everyone knows, yeah. Decades of legal and political attacks back and forth.
When these political heavyweights clashed in court, it seems like they weren't always just arguing the legal points. What other tactics did they pull out? How far did they go beyond the actual case?
They went incredibly far. Standard procedure, almost, was to attack your opponent's entire character, their social standing. The main goal often seemed to be denying them isonomia, equality of honor.
How did Demosthenes do that with Aeschines?
Well, Demosthenes, despite often being seen as the voice of the democracy, took this surprisingly blatantly anti-egalitarian line against Aeschines. He really played up his own, more aristocratic background.
Looking down on him?
Absolutely. He ridiculed Aeschines for his supposedly obscure origins, rumors about his mother being a dancer or prostitute, his father just described. And by doing that, Demosthenes was subtly placing himself above the jury, above the common citizens, even while claiming to speak for them.
Wow. So attack the man, not just the argument.
It was all about proving your opponent was somehow socially unfit, disreputable, and therefore, couldn't possibly be telling the truth or acting in the city's best interest. Character assassination was a core legal strategy.
That's fascinating, using the democratic court system to actually reinforce social hierarchy. And beyond these big political clashes, legal charges often zeroed in on personal misconduct, especially this charge of hubris.
Hubris was such a key concept. It gave the democracy a tool, a legal handle, to try and control the behavior of the rich and powerful.
And it wasn't just about, say, punching someone.
No, not at all. In Attic lawsuits, hubris covered way more than just a physical blow, like the infamous slap that Medius gave Demosthenes. That was part of it, sure. But it also included things like certain kinds of sexual violence and really any kind of behavior aimed deliberately at insulting, degrading, or humiliating another citizen.
So it's the intent to shame, to diminish someone.
Exactly. It's about the violation of dignity. And this reflects a deep-seated concern within the democracy, protecting ordinary people, the demos, from the arrogance and potential abuse of the wealthy elite. Hubris was a legal check on that aristocratic entitlement.
And philosophers picked up on this too.
Oh yes. Aristotle, for example, talks about hubris as something inherently wrong. There's no right time or right person to commit hubris against. The act itself is just bad. And Socrates, or Plato-Socrates, stresses that moderation, the opposite of hubris, requires constant mental effort. It's not the default state.
That level of legal scrutiny, especially when tied to political actions that could harm the city, must have carried immense weight. The system seems designed for accountability, and we see rhetoric, lies, and the legal fallout being immediate and sometimes fatal.
The whole situation with Philip of Macedon and the Phocian War is maybe the starkest example of this. The political fights in Athens over how to deal with Philip were deadly serious.
Demosthenes accused Aeschines of deception.
Vehemently. He argued that Aeschines basically tricked the Athenians with lies and false promises during the peace negotiations, leading to a treaty that was a disaster for Athens and fatally doomed their allies, the Phocians. That political accusation immediately became a legal charge, effectively treason or misleading the people.
And what were the real-world consequences of Aeschines supposedly misleading Athens about the Phocians?
Catastrophic for the Phocians. According to Demosthenes, Aeschines' deceptive reports convinced Athens not to send help. The Phocians found out they were abandoned, surrendered to Philip, and were essentially destroyed within days.
Within 5 days, the source says.
Yeah, 5 days. Demosthenes drove home the point. Aeschines' words, his political maneuvering, directly enabled the destruction of an allied state. In Athens, political speech wasn't abstract debate. It had real, immediate, and legally actionable consequences if it led to disaster. Accountability was paramount for the polis' survival.
So, if Athens was about managing conflict through this public rhetorical performance judged by citizens, Rome represents a really different path, a move towards institutions, procedures, the expert. The political fight seems to give way to the legal scholar, the jurist.
That's a great way to put it. The contrast is fundamental. Roman lawmaking, Roman jurisprudence, it moves decisively away from that Greek rhetorical model. It heads towards professionalization, towards systematic organization, almost a science of law.
And the key figures are these jurists, legal experts.
Exactly. The rise of the professional jurist is the big Roman innovation here. That period from Emperor Hadrian, roughly early 2nd century AD, through to Alexander Severus in the early 3rd century, that was the golden age. Law was constantly being refined, improved, yes, by emperors issuing decrees, but hugely influenced by the detailed, authoritative commentaries written by these top jurists. Their opinions gained the force of law.
So the intellectual heavy lifting by these scholars directly shaped the legal code. And this process eventually leads to that enormous complex body of Roman law that Justinian later tried to compile and simplify in his Corpus Juris Civilis.
That's the end result, yeah. An incredibly vast and sometimes unwieldy system built up over centuries.
What were some of the big intellectual breakthroughs from this period of the jurists? What concepts did they really nail down?
Well, one achievement the sources call a beautiful monument to their wisdom was how they analyzed and, crucially, separated fundamental legal ideas. They managed to draw a clear theoretical line between the obligation, the promise, the contract itself.
The agreement.
The agreement, yes, and the conveyance, the actual physical transfer of property.
Okay, that sounds a bit technical. Why was separating the promise from the physical act so important? What did that actually change for people doing business?
It was revolutionary for commerce. Before this clear separation, law was often incredibly formalistic. You needed very specific rituals, very specific words, transactions like nexum or mancipium, which often involved symbolic props like bronze scales and copper weights, all done in front of witnesses.
Very rigid.
Very rigid. The law cared almost entirely about whether you performed the correct actions the right form. By distinguishing the obligation, the underlying intent, the agreement, the promise from the physical conveyance, the jurists basically created the foundation for modern contract law in the West.
So.
They elevated the importance, the almost sacred nature, of the promise itself, the meeting of minds, above just the mechanics of the handover. It meant business could rely more on trust, on the agreement itself, rather than just these ancient, cumbersome rituals. It made commerce much more flexible and dynamic.
That's a huge shift, enabling more complex trade. But let's switch from abstract contracts back to the social reality. Roman law also had to grapple with the sheer scale of its own society, especially slavery and the process of freeing slaves, manumission. What does the evidence tell us about how common this was and how integrated former slaves became?
The evidence suggests manumission was, well, surprisingly common, especially during the Republic and early Empire. We hear about huge numbers like the General Sulla supposedly freeing 10,000 slaves at once.
10,000, wow.
Yeah, and when Emperor Augustus set up Rome's first fire brigade, the Vigiles, it was manned entirely by 7,000 ex-slaves.
So they were incorporated into civic structures.
Right. And maybe even more telling is the evidence from tombstones found in Rome itself. Archaeologists find funeral inscriptions commemorating far more ex-slaves, or liberty, than freeborn citizens. Some estimates suggest maybe 3 times as many.
That implies a huge amount of social movement, former slaves mixing with the free population.
It certainly points toward significant social mixing, yeah. A degree of permeability between the groups, although that freedom was always legally constrained in various ways.
Did the state get nervous about this? Did they try to limit the number of people becoming citizens this way?
Oh, definitely. There was concern, especially about the impact on the citizen roles in the army. Augustus passed a famous law, the Lex Fufia Canina, specifically to curb masters freeing too many slaves in their wills. It set limits, for instance. A master couldn't free more than 100 slaves via his will.
But no limits during his lifetime.
Not really effective ones, no. It shows this constant tension. Rome needed the labor slaves provided, but also felt a need to manage the integration of freed people into the citizen body.
Okay, let's look inside the Roman family structure now, which was dominated by the paterfamilias, the father figure with immense legal power over his household. How did the jurists create tools, like this thing called the peculium, that let business happen but still protected the father from unlimited risk?
The peculium was a really clever and essential legal workaround. It was basically a fund, or a small business or property, that was managed by someone under the father's power, typically a son, filius familias, or a slave.
Even though legally anything they owned belonged to the father?
Exactly. In strict law, the paterfamilias owned everything. The peculium functioned like a separate little pot of money or assets tied to that son or slave.
Why was that useful for the father, the paterfamilias?
It allowed him to use his sons and slaves almost like business agents, setting them up in ventures, letting them trade and make contracts, but crucially, it limited his own liability.
Ah, I see. Risk management.
Precisely. If the son or slave running the peculium business messed up and incurred debts, the creditors could generally only sue to recover assets from within that specific peculium. They couldn't usually go after the father's entire personal fortune.
So it ring-fenced the risk.
It did. And the jurists worked out all sorts of detailed rules around this. For example, if a son who was still under his father's power was given a dowry for his own marriage, but without his father's explicit say-so, any legal action related to that dowry later on could only be brought against the father up to the limit of the son's peculium. It let commerce expand without exposing the head of the household to potentially ruinous debts from his dependents' activities.
And these detailed rules also cover things like divorce, particularly protecting the wife's dowry.
Yes, the jurists were very focused on the financial side of marriage and divorce. They established clear rules. If a husband delayed returning his ex-wife's dowry after a divorce, he was automatically responsible for any loss or damage to that property during the delay.
Okay.
And more than that, he had to provide a guarantee, a security, that he would actively try to track down and recover any total property, like slaves, that might have run away during that time. It shows just how focused Roman law became on managing financial agreements and protecting assets, especially in family matters.
Let's circle back to the freedmen, the liberty. They gain citizenship, but that old relationship with their former master, their patron, it doesn't just vanish legally, does it? How did the law handle this lingering inequality, especially around something basic like the right to sue for being insulted?
No, the old hierarchy definitely cast a long shadow. The inequality was explicitly written into the law, particularly regarding the action for insult, the actio in factum. As a general rule, a freedman could not bring this legal action against his own patron.
So the patron could insult the freedman with impunity, legally speaking.
To a degree, yes. The law basically acknowledged that the patron retained a certain residual authority, maybe the right to reprimand or discipline his freedmen in ways that would be illegal if done by anyone else. It was a legal confirmation of the patron's enduring superior status.
But the jurists carved out an interesting exception when a third party, like a husband, got involved. That seems to suggest protecting the new family unit became more important.
It's exactly right. This is where you see the law trying to balance these competing social realities. The jurists decided that the husband of a freed woman could sue her patron for insulting her.
Ah, so the insult is seen as harming the husband's honor via his wife.
Precisely. It prioritizes the integrity and honor of the current marriage. The husband's rights and status needed protection from the patron's lingering authority over his wife. It shows the law recognizing the marital unit as a distinct entity that needed shielding, even from the powerful claims of the patronage relationship.
Okay, so as we move fully into the Roman Empire, the whole system of justice undergoes another massive transformation. We shift away from the more procedure-bound courts of the Republic toward something called cognitio, centralized discretionary power.
Yes, this is a huge change in how justice actually worked on the ground. Trials increasingly move away from the old system with magistrates and citizen juries. Instead, you get the personal cognitio, or inquiry, conducted by the provincial governor.
And he has the real power.
He alone holds the imperium, the capital power, within his province. He's usually an imperial legate or a procurator. And he's not advised by a jury, but by his concilium, a council of trained legal assessors. This setup meant he could basically handle serious criminal cases, just as he thought fit, as one source puts it.
Just as he thought fit. That sounds incredibly open-ended. So less about fixed rules and precedent, more about the governor's personal judgment, maybe influenced by his advisors.
That's the essence of it. The cognitio extra ordinum system gave the governor enormous flexibility.
Yeah.
Of course, he had to follow specific statutes where they existed, especially regarding the definition of crimes. But outside of those areas, he had a lot of leeway. He could look at how previous governors handled similar cases, consider general instructions from the emperor, or even in theory come up with his own solutions, guided by his council.
And the emperor is hovering above all this.
The emperor is the ultimate authority. He could, and sometimes did, intervene directly, especially in important trials involving senators back in Rome, although sometimes he'd let the Senate handle its own affairs, as long as the case didn't touch upon the emperor's own dignity and safety. But the governor's power in the provinces derived directly from the emperor.
This is where the political structure starts to really dictate the legal outcome for ordinary people in a very direct and frankly brutal way. By the Severan period, around the early 3rd century AD, the law openly distinguishes between people based on social status. This terrifying two-tiered system of justice emerges.
It's arguably the bleakest aspect of Roman legal development. This formal stratification becomes embedded in the law. You have the honest tiers, literally the more honorable ones, the elite.
Who are they typically?
Senators, equestrians, the sort of second tier of the aristocracy, high-ranking military veterans, local city councilors, decurions across the empire, basically the upper crust. And then you have everyone else, the lower ones.
The vast majority of people.
The vast majority, yes. Provincials, peasants, artisans, laborers, urban poor.
And the difference wasn't just social prestige. It dictated how you were punished for the exact same crime.
Exactly. The punishments were deliberately designed to reflect and reinforce this status divide. They aimed to preserve the dignity of the elite, even in punishment, while maximizing the public terror and degradation for the lower classes.
What kind of differences are we talking about?
For the humiliores, the standard punishments for serious crimes were incredibly harsh and often involved public spectacle. Things like being thrown to wild beasts in the arena damnatio ad bestias or obicentur,
Horrific.
or being burned alive vivi exequentur. Torture was also much more readily applied to humiliores during investigation.
And for the elite, the honestiores, if they committed the same crime.
They were generally spared these degrading public executions. Their typical punishment was relatively quick and clean execution, usually beheading capiti punitur. It preserved their dignitas, their social standing, even in death. The law itself was actively maintaining the social hierarchy through the very method of state killing.
And there were procedural differences, too.
Yes. For an honest year, any sentence of deportatio, which was capital punishment involving exile and loss of property if handed down by a provincial governor, it couldn't be carried out until the emperor himself had confirmed it. The elite essentially had an automatic right of appeal to the highest authority. The humiliores generally did not.
So a starkly unequal system. Yet, despite this incredibly stratified justice system, the empire did take one huge step towards legal unification. Caracalla's edict in 212 AD granting Roman citizenship to nearly everyone.
The Constitution Antoniana, yeah, a landmark moment.
What did that grant of the franchise given to almost all free people in the empire actually achieve on a practical level? Did it level the playing field?
It was undeniably significant administratively. Caracalla, in effect, created the world of Rome. It massively simplified the incredibly complex patchwork of different legal statuses that existed across the provinces. Suddenly, almost every free person was, legally speaking, a civis Romanus, a Roman citizen.
So, unification, but maybe only skin deep.
That's exactly how the sources describe it. Unification only in the narrowest sense.
Why the narrowest sense?
Because while everyone, or almost everyone, now held Roman citizenship, their actual local community status often didn't change much. Whether you lived in a tiny village, vicus, a self-governing town, civitas, or a privileged Roman colony, colonia iuris italici, those local identities and structures largely remained. Roman citizenship was like an overlay. It supplemented your local status. It didn't erase it.
And critically, it didn't erase the honestiores humiliores distinction in the courts.
Absolutely not. That two-tiered system of justice based on social class continued, and in some ways even intensified, after Caracalla's edict. So, yes, nearly everyone was a Roman citizen, but the law still treated the honorable citizens vastly differently from their humbler ones, especially when it came to punishment. You might all be wearing the toga, so to speak, but only one group was reliably safe from being thrown to the lions. Hashtag outro thing.
Well, we've covered an immense amount of ground today. We've journeyed from local customs and the heated political debates in Athenian courts where winning arguments could literally save your life.
Right, where rhetoric was power.
All the way to the highly structured, codified, and deeply status-conscious legal system of the Roman Empire, where your social rank determined how the state could end your life.
And the really striking theme throughout, I think, is this constant interplay. Every time legal thinking gets more sophisticated, whether it's the Athenians trying to replace blood feuds with state trials, or the Roman jurists making these incredibly subtle distinctions about contracts.
Yeah, that obligation versus conveyance thing.
Exactly. Every step forward in legal technique seems almost immediately paired with a way to reinforce existing power dynamics or create new ones. Law develops, but it also consistently reflects and defends the social order, whether through persuasive speech in Athens or imperial edicts from Rome.
So what's the takeaway for you listening today? We've seen how practical needs, like facilitating trade or keeping social order, drove the creation of legal ideas that lasted for centuries. But we've also seen, very starkly, how political fights and social hierarchies decided whose life the law protected more and whose death was considered more dignified.
Maybe a final thought to chew on, building on that. We mentioned the Roman jurist Papinian defining adultery primarily in terms of a married woman having relations with another man, because the core issue was the potential for illegitimate children, messing up inheritance and lineage.
Right, the focus was on property and family lines.
Precisely. So the question becomes, how much do our modern legal definitions, even for things that seem universal, like crime, injury, or even concepts like consent or harm, how much do they still carry echoes of these ancient priorities? Do they still maybe subconsciously prioritize things like property, status, or established relationships over truly universal ethical principles? That historical baggage that focus on who matters more in the eyes of the law, it's something that arguably still shapes our legal thinking today, often in ways we don't even notice.